Hi, what I'd like to do here today is give you an introduction to patents in the United States. Before I really begin, though, I feel compelled to state the following up front. The goal here is not to give you the tools and knowledge so that you can figure out patents on your own and file your own patent applications. In fact, my objective is just the opposite. I want you to realize that there is no way you should ever contemplate doing this by yourself, and that you absolutely must seek professional help, probably from a patent attorney, when you believe that patent protection may be relevant. So I see my role as a business consultant who is advising you how to navigate some of the legal waters you will encounter as you develop and monetize innovations. In this regard, you need to understand why you might need legal protection, what roles intellectual property could play, when you should seek outside assistance, and what things you should or should not do prior to meeting with an expert. I also would like you to have a feel for the vocabulary that underlies patents so that you can speak more knowledgeably with your patent attorney. But in no way should you feel empowered to file your own patent application or address the Patent and Trademark Office without expert assistance. So, yes, I am going to cover some of the basic elements of obtaining and maintaining a patent, but I don't want you to get buried in the minutiae that are better left to others. Before we even get to the basic elements of patent protection, I want to step back for a moment and remember why we even have a patent system, which is to provide inventors the incentives to move forward with their creative ideas and to disclose their innovations to the public. Given this, patents are only appropriate for inventions that someone creates, as opposed to those that are already in public hands. In other words, if the invention is already out there, then it could only harm society to allow someone to legally control it. And with patent reform, out there now means that the information is publicly known before the inventor files the patent application at the Patent and Trademark Office. The patent system also provides incentives for inventors to disclose their developments quickly, as opposed to keeping them secret, so that the public can learn from their innovations and contribute their own ideas as early as possible. It does this by granting priority to the inventor who wins the race to file an application at the Patent and Trademark Office, among other things. On these next two slides, I listed several general considerations that are often relevant to decisions regarding patents. The first is that the patent grants its owner the exclusive right to make, use, or sell the invention in the United States. So think about this just for a moment. Of course, with a patent, the patent owner can make, use, or sell the invention if that's what he wants to do. But there's nothing that says that the patent holder actually must do any of these things to get the patent or keep it. Thus, a patent owner can be totally passive without ever making or selling the product and still maintain rights over the invention. In legal circles, we often say that a patent holder does not have to practice the invention to maintain rights over it. Also, patent rights are exclusive, meaning that nobody else can make, use, or sell the invention without permission from the patent holder. So, if you put these two concepts together, it means that as a patent owner, I don't have to actively practice the invention, or in other words, manufacture, sell, or use it. But at the same time, I can also prevent anyone else from doing these things. So I think you can see how this might be good for, let's say, the garage inventor, who creatively tinkers with ideas, but never plans to actually engage in the business side of developing or selling products. The patent gives the inventor the power to negotiate with others who may want to bring working products to market because they can't do so without his permission. So this is all fine and good. However, there is a potentially darker side to all of this because sometimes firms buy up patent rights with no intent of ever making or using the inventions, but only to wield them as weapons against others. For instance, technology firms often collect patent rights for defensive purposes, so that they can threaten countersuits if their competitors ever charge them with patent infringement. It's like, you're suing me? Let me see what I have that I can use against you. Oh, here we go. Here's one that looks credible. Okay then, if you don't back off, then I'm going to sue you for infringing my patent. And in the end, you're going to regret that you ever brought this up. Another related issue that has more frequently made headlines involves firms that buy up patent rights to more affirmatively chase alleged infringers. Sometimes these firms are pejoratively called patent trolls because they are perceived as ugly monsters sitting at the bridge waiting to unreasonably frighten anyone who might dare to cross. So let me say at the outset that these businesses do not always deserve to be defined in such a negative way. And so their supporters prefer names such as non-practicing entities rather than patent trolls. Because understand that inventors often don't have the time, expertise, or resources to enforce their legitimate patent rights in the complex world of patent litigation. For this reason, they may be better positioned to capitalize on their creations by working with experts, often patent lawyers, who have the knowledge, focus, and financial strength to handle this part of the business. So these firms make deals with the inventors to enforce their patent rights in exchange for a cut on the returns. And of course, such firms may be more effective if they have a wide quiver of patent arrows. And so they may own numerous patents, all without any intent of actually practicing the inventions. Thus, there definitely are non-practicing entities that legitimately serve to improve the efficiency of the patent system for typical inventors. Having said this, there are other firms that engage in tactics that make them appear as unscrupulous bullies, which has led the press to call them patent trolls. For instance, they may threaten small manufacturers or their customers, claiming that they are violating a patent that they own, and demand a royalty fee to avoid expensive litigation, even though the basis for the charge may be very dubious. For example, the patent claims may not cover what the owner alleges, or the patent may be weak and subject to challenge. Nonetheless, think how you would react if you received a letter alleging patent infringement and informing you that you will be sued unless you pay some defined fee. Consider the time and energy this will soak up, the litigation expenses you'll have to pay, and the potential consequences if you end up losing. I think many of you would pay, even an amount like $10,000, just to make the hassles of this problem go away, even though you are very skeptical about the legitimacy of the charges. And I imagine when the episode ends, you are probably not going to have kind things to say about what happened, and you're going to wonder how these firms are even allowed to operate. All right. Next on my list here regards remedies for patent infringement.
which are potentially significant. As you might expect, you could be able to get lots of money for the damages you incur because of the infringement. And this can be determined by any method that makes sense. Like, how many fewer units did I sell because you unlawfully made something similar? How much did I have to reduce my price to compete with your units? What amount would you have paid to use the patented invention had we negotiated a royalty deal? And so the numbers are all over the place, but one statistic I have seen indicates that the average amount of money awarded as patent damages is something like $24 million. In addition, the court can issue what's called an injunction, which prevents the infringer from continuing to make or sell the product without permission. We'll have to get into this a little more later, but you probably assumed that a court would always order an infringer to stop doing the things that violate the exclusive rights of the patent owner. However, although injunctions are pretty common, we will find that you can't always count on a court ordering one, even when the patent owner prevails. Oh, and one other thing that just adds an exclamation point to this whole topic of remedies. If you convince the judge that your situation is exceptional, meaning that the infringer boldly and willfully violated your rights while, like, giving you some inappropriate gesture, then you can get up to 3 times the proven damage amount, which really adds frosting to the remedies cake. Now we come to the registration hurdles for getting a patent, which means meeting the standards and paying the costs. So, in most situations, the 2 most important standards are that the invention be novel and it must be non-obvious to one skilled in the art. We're going to spend quite some time evaluating the basics of each of these standards. And in this regard, the United States adopted major reforms to its patent laws in legislation called the American Invents Act that became effective in 2013. And perhaps its greatest change was to the novelty standard. So we will definitely see what that is all about. Along with being novel and non-obvious, an invention also must be the proper subject matter for a patent, which includes pretty much everything, so it's usually not a significant issue. However, we'll see that controversy does arise here with biotechnology, internet business methods, and computer programs. Okay, as we go through the IP options to protect new innovations, we will learn that sometimes you have to make choices. For instance, one of the bargains you have to make in exchange for patent protection is to disclose the important aspects of your invention to the public, which obviously precludes the option to pursue trade secret rights. And so you may think, fine, I will rely on trade secrets until the PTO grants me a patent. And at that point, I will give up the secrecy because now I can rely on the patent to keep others from taking the crown jewels. But the decision is not going to be so easy, because the PTO is probably going to publish your patent application, including all the important details about the invention, before the agency decides whether it will actually issue the patent. So think about this. You go for a patent. Your information is disclosed. And then the PTO does not grant the patent because it believes your invention does not meet, let's say, the non-obvious standard. What this means is that you have just freely given away what previously had been valuable secrets, and now there is nothing you can do about it. At this point, you will probably wish that you had never embarked on the patent road. So I just want you to recognize that the patent process involves certain risks that you need to consider sufficiently early so that you can properly address the costs and benefits before moving forward. Next on this list is duration. And obviously, the length of time that the patent will protect the invention is important. Although there are some exceptions, the general rule is that the patent lasts until 20 years after the application filing date. So, if it takes the patent office 4 years after you file to grant your patent, then you will only have 16 years of actual patent protection, because coverage only starts when the patent is approved. And so now I want to further highlight the risks and costs of the patent process. And this is something that I can never overemphasize. I have already mentioned the costs to get a patent and the trade secret risks you may face if your application is disclosed prior to approval. So let's say you pay the money, cross your fingers, and everything goes great at the PTO, which then issues the patent. You may think, oh boy, now I'm golden. Well, yes, things are better, and maybe you can let your breath out a little bit. But you certainly can't totally relax, because lots of things can still go wrong. For instance, suppose a competitor starts to make a product that you believe violates your patent. If he doesn't just roll over, then you're going to have to sue him. And trust me, that will cost more than you ever thought possible. Again, the figures are all over the place, but according to some studies, the median cost to bring a patent infringement suit is $1.2 million, which primarily consists of fees for attorneys and expert witnesses. So you're going to have to be ready to defend your rights with your wallet. And trust me, there's no assurance that you will win when you sue. After all, the competitor may prove that its product doesn't violate the claims in your patent. Also, litigation brings its own risks because a judge may determine that the PTO was wrong in the first place to grant you the patent because the examiner made a mistake when concluding that the invention was novel and not obvious. So now you have spent all this money, and in the end, you lose your patent, which means your secrets are out there and there's nothing you can do about it. If that's not enough, there are also ways for people to simply step up and challenge your patent, even without being sued. One way is to request a proceeding at a special court within the PTO, where the judges will review your patent and possibly invalidate it because they believe the examiners made a mistake. And believe me, there are other things you need to be wary of as well. So the bottom line is be prepared for a potentially expensive and difficult road, even after receiving the patent. One other introductory item worth noting regards the Federal Circuit Court of Appeals, which is where all appeals from lower court patent decisions are reviewed. If you've had a business law class, then you know that the typical route in federal court begins with a trial at the district court, and the loser then may appeal to a regional appeals court. So, for instance, if I had a federal grievance, I might sue in the district court for the Central District of California. And if I'm not satisfied with the outcome, I could appeal to the Ninth Circuit Court of Appeals, which covers several western states, including California. From there, if things didn't go as I wished, The next step would be to the United States Supreme Court, but it only reviews a very small number of disputes. So the result is that you typically have trial judges in the different regions following the decisions of their respective courts of appeals. And these circuit courts sometimes apply the laws in different ways. In the old days, this actually led to some significant differences with how patents were evaluated in various regions of the country. For instance, courts in some areas were far more likely to invalidate patents than those in other locations. Partially to remedy the inconsistencies, Congress established that all appeals from the district courts, no matter where located, would go to one place, the Federal Circuit Court of Appeals. Since its rulings govern the decisions of all the lower courts, this then greatly unified patent policies across the country, even when the cases don't make it to the Supreme Court. It also means that the Federal Circuit has unusual importance for patent policies. You can almost think of it as the Supreme Court for patent disputes, although, as in all matters, the actual U.S. Supreme Court does have the final say. And we will see that sometimes it doesn't agree with the Federal Circuit. To end this overview, I want to briefly show you a few of the changes that were implemented by the American Invents Act, the major patent reform effort that took effect in 2013. So, prior to 2013, the United States clung to the concept that the invention date should be the pivotal moment for patentability. In other words, if two inventors had been working on the same project at about the same time, then the first one who invented it would be entitled to the patent. Also, when deciding if an invention were new, the question was whether there was anything out there in public hands before the invention date. With the American Invents Act, however, the patent application date has replaced the date of invention as the key determinant. So now we consider which inventor filed the patent application first, and evaluate whether there has been a public disclosure prior to the date of the application. By making this change, the United States actually joined the process already used by all the other nations around the world. The new law also addressed concerns that the Patent and Trademark Office was being overwhelmed and consequently granted patents on inventions that didn't merit them. To this end, the Act provided new avenues for members of the public to challenge PTO decisions. In addition, the Act strengthened something called prior user rights, which allows businesses that had privately used inventions to perhaps prevail if sued for patent infringement. I will clarify what this means when we look more fully at the novelty standard. Anyway, these are a few of the important changes, but there certainly are more. Okay, that's pretty much all I want to say in this brief introduction to patents. Next on the agenda is to look more closely at the standards for obtaining a patent. And in this regard, the first one we're going to review concerns novelty. Until then, have a good one.